Hello, everyone. Welcome to Court with Krissy. Attorney Pajak thinks it's her lucky day. Too bad, but at least she can laugh about it. Enjoy the details of this clear record with Judge Hunter. I hope you like it. Court with Krissy is now in session.
Record of the matter of People of the State of Michigan versus Leon Everett Smith, file 23-5267FH.
Good morning.
Mr. Morton. Good morning, Ms. Pajak. Just give me one moment. Mr. Morton, are you here on the Leon Smith matter?
Yes, I am, Your Honor. Yes, I am, Your Honor. We are handling the appeal on behalf of Crawford County Prosecutor's Office, and so I wanted to make myself available for questions.
Thank you. Appreciate that. And if each of the attorneys then could please state your appearances for the record.
Christine Pajak, appearing, I guess, on behalf of Mr. Smith for the time being.
And may it please the court, Brent Morton, Brent Morton, Assistant Attorney General.
Thank you. Counsel, I appreciate each of you being here today via Zoom. We're here on the motion to withdraw on the appointment of substitutes. Counsel, I've had a chance to review that. Counsel, and I've also seen that there's been no response. I didn't necessarily expect one from the AG's office. Did you have any written response that was filed, Mr. Morton?
No, Your Honor. First of all, thank you for letting us appear by Zoom. Secondly, I just wanted to appear to make myself available for questions. We never want to interfere with the choice of an appointed counsel.
All right, thank you. Ms. Pajak, I see that Mr. Smith is not here. Did you arrange a writ for his appearance today?
He is out, actually, and asked me if he needed to appear. I talked to the people at Max, and they told me to advise him that he needed to appear if he had something to add, which is what I told him. I assume he does not.
And that's fine. I'd waive his appearance. I don't need him to be present to decide this issue. Ms. Pajak, I've had a chance to read your written motion. Is there anything you wanted to add by way of oral statement to the court?
No, I think what's in the pleadings speaks for itself. There's been a breakdown in the attorney-client relationship, and I think Mr. Smith has made that pretty clear, and I agree.
All right, then the court makes several different findings, and I apologize for the length of these findings, but given the background, I think it's absolutely necessary. This court has been involved on this case for quite some time at the circuit court level, and although the circuit court proceedings were relatively short, I think that the bind over was sometime in the late 2023, and we were able to have a trial relatively soon in 2024. However, even though the short period of time it was pending in the circuit court, I had a great deal of involvement with this case, and I'm aware of many other involvements at the district court level, of which I'm sure the attorneys are as well, because you, Ms. Pajak, had requested the district court transcripts. I was never made available or had those made available to me during the circuit court proceedings, but some background is absolutely in order in context of this motion to have a withdrawal of the current appointed counsel and for a substitute attorney. The offense date that was claimed by the prosecutor in this case was September 17th of 2021. There was a prelim waiver on 10/31 of 2023. So almost over 2 years of time that things progressed in the district court level. And those primarily dealt with issues regarding competency or criminal responsibility. And again, I was not privy to any of those things other than the fact that I was made aware of them by the prosecutor, by Mr. Smith. When Mr. Smith first appeared in the circuit court, he appeared respectful, calm, and had relatively even-keeled demeanor. He requested to represent himself. I went through the long Anderson waiver requirements, and I ultimately allowed him to represent himself. Soon thereafter, however, things started to take a turn to the negative, in my estimation at least. And I say that because soon after that initial waiver where Mr. Smith appeared very calm, collected, and had even-keeled demeanor, as I explained, I then received some bizarre communications. In bizarre, these are all captured on the court record. The attorneys are likely already aware of them, but bizarre because I received an email from a defendant representing himself, charged with 4 felony counts of resist and obstruct, which was fairly nasty in tone and demeanor. It was swearing, and it was saying all sorts of things that were inappropriate, let alone the fact that he had communicated to me as the trial court judge directly to my email account with the county. I had a hearing, therefore, in person and explained those things to Mr. Smith. Mr. Smith continued to want to represent himself. He continued to waive counsel, and he continued to refuse to have counsel appointed to represent him. It was also brought up either at that hearing or another by Ms. Koch, our prosecutor, that at the district court level, Mr. Smith had been represented by at least 2 different court-appointed attorneys that fired those attorneys and wasn't happy with their performance. Mr. Smith, at all times in the circuit court until the Tuesday before our Friday trial, refused counsel's assistance, waived the assistance of counsel, and to me, invalidly did so. And even though I had some concerns about his interactions with the court by emailing me directly or by saying and doing things which appeared illogical to me, I continued to find him to be of sound mind, and in the sense that I allowed him to waive counsel and found it to be freely, knowingly, intelligently done. Mr. Smith then appeared after filing various motions beyond the motion cutoff date, asking me to be disqualified, asking the prosecutor to be disqualified, asking for me to dismiss the case. I found all of those things not only to be not compliant with the court rules, but also untimely. I denied all of them. I also noted at 2 different hearings, Mr. Smith wanted me to revoke his bond, offered no reason for it other than he did not believe there was any merit to the charges, but wanted me to revoke his bond so he could start serving a prison sentence. That was his words, not mine. I reminded him that I would not treat lightly any request to have bond revoked, and if there was a basis for it, I would revoke bond. But unless there was any type of an agreement or a situation where he either violated the law or otherwise failed to appear in court, I was not going to do that. I explained that to Mr. Smith. I did not revoke his bond. At all times, though, he wanted to be convicted, is what he kept telling the court. He wanted to be convicted so that he could appeal and ultimately have his convictions overturned in the Court of Appeals or the Supreme Court. We proceeded with a bench trial. Mr. Smith validly waived his right to a jury trial after I had the required colloquy under Michigan law with him. And we proceeded to a bench trial. And before that date, the Tuesday again before the Friday trial, Mr. Smith at one point told me he wanted appointed counsel. When I told him that necessarily would mean adjourning his trial, he told me he did not want to adjourn his trial. I told him that he absolutely had a right to trial, but if I was going to appoint an attorney, it would be absolute malpractice for me to allow an attorney to come up into a new case for felony charges 3 days before trial. When I explained that to Mr. Smith, he decided to not have an attorney. The court attempted to have an alternative attorney arranged to be a standby attorney, but Mr. Smith was clear when I asked him about it. He wanted to have his trial on that Friday afternoon, and he would not accept an adjournment. And so we went forward with the trial. It was made clear to me before trial and to Mr. Smith that even standby counsel was not available. It's not surprising. There was 3 days time period to try and get that attorney, and Mr. Smith refused the service of Mr. Thompson, who was our court-appointed MIDC coordinator at the time. Mr. Smith then proceeded to bench trial. I proceeded to go through in detail what my findings of fact and conclusions of law were. Mr. Smith was clearly dissatisfied with those and objected to them, which he's entitled to do. But he was dissatisfied and objected to them to the point where he stopped listening, he stopped communicating with the court, and he refused to abide by the required terms of complying with the PSI process. I tried to be patient. I took a break. I didn't even do anything that I was intending to do until I gave 5 minutes for Mr. Smith to talk with other people that were in the courtroom supporting him, other witnesses that testified at trial. I ultimately came back on the record. Mr. Smith, when given the choice between completing the PSI process, cooperating with it, or the court taking other options, told me, quote, jail, unquote. In other words, he wanted me to put him in jail so that he could start serving his time so that he could be apparently successful on appeal. Then he did get sentenced by the court. I gave him 2 days credit and 2 days jail, fines and costs, and otherwise considered the matter done. Mr. Smith, as he had the right to do, then requested to have a court-appointed attorney appointed for the purpose of an appeal to the Court of Appeals, which he had by right because he had a bench trial. Counsel was appointed. Lots of things happened. Counsel ultimately, I think, passed away. The court, on behalf of the court approves on behalf of the Michigan Indigent Defense Commission and then SADO, State Appellate Defender's Office, approximately $5,900 to that first attorney. Ultimately, later, there was an attorney ordered by the Michigan Court of Appeals to have a new attorney appointed because of the death. That's when Ms. Pajak entered into the system and has been representing him since. Ms. Pajak then requested additional transcripts, got up to speed on the case because obviously now the case is ready to be heard in the Court of Appeals by oral argument. The court would note all of that background in light of and in context with the instant motion to withdraw. I have no doubt whatsoever, Ms. Pajak, that you've accurately recounted that Mr. Smith told you via email, you're fired. I have no doubt that he has expressed to you that he doesn't want you to represent him. That is absolutely consistent with what Mr. Smith has been doing throughout trial court proceedings. He is firing every attorney he's had and or asking to represent himself and then vacillating at least somewhat on it. And I say at least somewhat, not to the point where I denied his right to represent himself, but at least to the point where he's made it difficult for himself to proceed or for his attorneys to proceed at all times throughout this case. All that context is important to the court because it dictates some of the background here. The court would also note that I have a fiduciary responsibility to the County of Crawford. Part of that fiduciary duty requires me to examine and then ultimately approve or not approve appellate requests for payment. Again, as I've indicated, the first attorney that unfortunately passed away has already requested and was paid by Crawford County for the indigent defense of Mr. Smith on appeal. It's a total amount of, and I'm looking at the ROA to confirm these amounts. The first payment was the amount of $5,135. That was on 11/13 of 2024. Then I had a transcript amount, $287. That was for additional appeal transcripts given to Crawford County, and that was for the district court matters. The court then also has approved already $1,683.83 to current counsel for the work that she's done, and there's nothing wrong with that payment. Ms. Pajak clearly has been representing the interests of Mr. Smith as she's required to do. So the court notes in totality, there's been already approximately just shy of $7,000 or just over $7,000 in approved funds. And while the court doesn't take any umbrage with that fact remains the fact. And the fact remains, just as I explained to Mr. Smith on Tuesday before his Friday jury trial, to the extent the court appointed new counsel as is requested in the instant motion, necessarily that new counsel would, to be constitutionally effective, need to come up to speed on the new matter, would need to review the hundreds of thousands of pages of transcripts in this case, and would need to recreate the wheel. Ms. Pajak appears to the court to be fully ready to make the arguments, and although she has the ability to and is obligated under the Michigan Rules of Professional Conduct to file a motion to withdraw when her client says that you're fired, the court rules are also explicitly clear, and so are the Michigan Rules of Professional Conduct. And that is Michigan Rule of Professional Conduct 1.16C. That states explicitly, when ordered to do so by a tribunal, a lawyer shall continue representation, notwithstanding good cause for terminating the representation. So my finding is there is good cause for terminating the representation. Ms. Pajak is in between the proverbial rock and a hard place. She has been told by her attorney, or excuse me, by her client that she is fired, and that dictates that she filed this instant motion to withdraw. However, given all of that voluminous background and my personal knowledge of Mr. Smith's difficulty, I do not find that him simply listing you as fired is sufficient and is enough to have you released. And while I apologize, Ms. Pajak, because I recognize the difficult situation that not only puts you in now, but will put you in the Court of Appeals, this case, at Mr. Smith's urging, needs resolution from the higher courts. If that resolution is that Judge Hunter erred and a new trial is needed or the conviction should be vacated, so be it. If that resolution is that the conviction stand, so be it. But either way, it needs to happen. And to the extent the court found that there was a proper basis to substitute attorneys, not only would it delay Mr. Smith's ability to have that happen and the people's right to have that happen, it would also severely impede my ability to maintain my fiduciary responsibility to Crawford County. I'm not willing to do that. So while I respect your motion, Ms. Pajak, and that there are proper grounds under MRPC 1.16C, I'm ordering that you continue to represent Mr. Smith. Mr. Morton, I know that you're not really involved in this case, but you're generally the prevailing party because the motion is being denied. Can you prepare an order that just says, for the reasons stated on the record, the motion is denied?
I will, Your Honor.
Do you have any questions or statements for purposes of appellate review you'd like to offer, Mr. Morton, on behalf of the people?
I do not, Your Honor. Thank you very much.
Ms. Pajak, did you have any statements for purpose of appellate review or other questions that the court could answer on behalf of the defendant?
I have no questions. I understand your ruling. I'm not going to thank you. But
Counsel, again, I apologize. I recognize I put you in a difficult position. It's not my intention to do that, but I do feel duty bound to address all of these issues as they arise. Good luck, counsel, on both sides. Thank you.
Thank you. I understand, Your Honor. Thank you.
All right, thank you. Recess on that matter.